This video extends the lesson, Day 3, Budapest, Employee Consent, and contains an in-depth comment of the Articles 7 and 88 of the GDPR. Please find in the description below references for the course. Before GDPR, many companies relied on their employees' consent to process their personal data, and short consent was often included in employment contracts for that purpose. This approach's benefits are obvious, rather than determining which legal basis, from several potential legal bases for the processing of employee data, applies to each category of employees' personal data. An employer can simply rely on an all-encompassing consent. Under the General Data Protection Regulation, GDPR, valid consent requirements have been made much stricter. Consent must be freely given, specific, informed, and revocable. The GDPR expressly states that, where there is an imbalance of power between the party giving consent and the party receiving it, consent will not be valid. In the employment context, it has long been acknowledged that there is such an imbalance between employer and employee. This means that it will be challenging for employers to rely on consent to process employees' personal data under the GDPR. However, in reality, the legal basis to which most commercial employers turned is legitimate interests, that is, that their legitimate interests in processing employees' personal data outweigh the general privacy rights of employees. This widened the scope and assumed much greater prominence under the GDPR. Processing must not only be legitimate but must also be necessary, proportionate, and implemented in the least intrusive manner possible. The CNIL has recently done some guidelines which include a comprehensive grid of applicable legal bases for processing related to each standard HR purpose. Guidelines include compliance with a legal obligation, performance of a contract or steps taken before entering into an agreement, legitimate interests, or tasks performed in the public interest or the exercise of official authority vested in the controller. For example, for recruitment purposes, pre-contractual measures or legitimate interests are acceptable legal bases for the CNIL. However, the guidelines remind controllers that those suggested legal bases must be adapted to specific contexts and situations. Regarding the consent of employees or applicants, the CNIL also reminds organizations that these individuals can hardly provide free, specific, informed, and unambiguous consent due to the imbalance of power in the relationship between them their current or future employer. The CNIL concludes that consent can be used as a legal basis for processing employee/applicant personal data, only in cases where there are no consequences for them. For instance, the recording of a promotional video in a workspace that shows identifiable employees may be based on the employee's consent if 1. The employees have a real choice as to whether or not to appear in the recording, and 2. The employee's choice has no impact on them, particularly concerning working conditions, remuneration, advancement, etc. Check it out here for further details about categories of personal data, retention period, and peer.